Let in our first couple guests, and I'll keep on letting folks in as they trickle in here. Welcome everyone to this month's LEOP webinar on Minnesota's financial orders for protection, and discussing some new changes to the law that have been put in place quite recently. Our presenter for the day is Jen Bueno. She is one of our lovely staff attorneys in the Elder Law Unit, along with myself. And just a friendly reminder before we get started, please don't enter any personal information into the chat, any phone numbers, addresses, social security numbers, credit card numbers, anything like that. We are definitely happy to take general questions as they come or at the end of the presentation. And then, of course, we will upload this recording to YouTube at a later date. If anyone has to dip out early, it'll be available at a later date. But other than that, that's all I have for you. I think I'll turn it over to Jen if you are ready to go.
Thanks, Isaiah. Hi, everyone. I'm Jennifer. I'm presenting today on Minnesota's Financial Order for Protection. It's a great new law that just came into effect this year, and it's a great shield for vulnerable adults. So let's get right into it. I wanted to share the agenda. We're going to be covering first the crisis impacting vulnerable adults. So we're going to look at the problem, why this law was needed in the first place. Then we're going to examine the statute itself, look at the citation, and also give you an overview of it. Then we were going to take a look at the definitions of how does the statute define a vulnerable adult. We'll do the same with how does the statute define financial exploitation. And then we will discuss the legal standard for this new statute. And what elements the courts will be looking for when they go to find if there is financial abuse or financial exploitation that has occurred. And then we will go over who can file these specific kinds of order for protection and what relief can the court order. We'll discuss emergency ex parte orders. We'll also talk a little bit about what you can expect in the evidentiary hearing process and briefly go over how to file for an order of this kind and what key documents you'll need. I'll direct you to where you can find the court forms that are relevant to this and just do a quick check-in on the implementation. How is this going? Are we seeing petitions? What are the outcomes we're seeing? What are the legal arguments we're seeing, etc.? So starting first with the problem, why this law was needed in the first place. It's a growing crisis. Financial exploitation of older and vulnerable adults has been increasing in Minnesota. Previously, vulnerable adults were left without protection when they were experiencing financial exploitation. Pursuing that in the court was very difficult in real time. Right now, or prior to this kicking in, we really only had the domestic abuse order for protection, which did not include protecting someone from financial abuse. It was really more so physical abuse and threats of physical harm. In examining why stopping exploitation in the courts was really difficult up until now, it's because criminal prosecution was very slow. The route of doing a conservatorship was very costly, and it did take away the victim's rights. And sometimes you're not necessarily looking to do that. And as I mentioned, this specific type of exploitation that was being committed by caregivers, family members, even AI scammers, people who are in positions of trust, the abuse they were committing was not one of a physical nature. And so that original OFP, that domestic abuse OFP that was already in existence, did not cover the situation appropriately. I want to draw everyone's attention to a great article that came out middle of last year by the bench and bar. This was once everyone started learning that there would be this new OFP, financial OFP that would be coming out. They made a great article on it. Miss Jill Sauber wrote Elder Snare. And I have a quote here from that article, and I just wanted to take a moment to read it. It has some great observations and statistics in it. It says people 65 and older will make up 18% of the nation's population by 2030, and they have more to steal. Boomers control 51.6% of the nation's total wealth, and they are expected to pass down an estimated 74 trillion to the next generation within the next 2 decades. That is a financial passing of the torch that's already being called the Great Wealth Transfer. It's only natural that awareness building and prevention efforts focus on the older population because the social impact of widespread economic losses would create a domino effect that would be devastating to younger generations. And Minnesota is the second state to enact a financial exploitation injunction law like this OFP statute. We're leading the charge in protecting vulnerable adults from exploitation and scams. So let's take a look at the statute itself. The statute is called an order for protection against financial exploitation of a vulnerable adult. And you can find that under Minnesota Statutes section 609.2334. And this came into effect starting January 1 of 2026. Looking at the overview, it's a civil remedy, and it allows a petitioner to seek a court order that would grant protection against financial exploitation of a vulnerable adult. This was signed into law by Governor Walz on May 23rd last year, and the nature of the remedies are civil, not criminal. Before this, the only financial exploitation laws we had were of a criminal nature. So this is the first of its kind within the civil realm. It's designed to stop harm and protect assets rather than punish conduct. However, violations of this order can eventually result in criminal charges depending on if they've committed any other prior violations of that nature within the last 10 years. So let's look at the legal definition based on this statute. Who is a vulnerable adult? This definition came from the existing one of vulnerable adults that's under a different statute, Minnesota Statute Section 626.5572, Subdivision 21. A vulnerable adult is any person who's 18 years or older who, because of a physical, mental, or emotional condition, cannot fully care for themselves or protect themselves from harm, including adults who live in licensed care facilities or receive professional care services that make them dependent on others. So there's 4 qualifying categories under that statute for what is defined as a vulnerable adult. It's facility residents, it's licensed service recipients, it's personal care assistance recipients, and any persons with physical, mental, or emotional dysfunction that would impair their ability to care for themselves. I do want to point out that this law is not limited to the elderly or older persons. Any person who is 18 or older who meets that definition, who falls within one of these categories, would qualify as a vulnerable adult. So let's look at the legal definition under the statute for financial exploitation. Financial exploitation is incorporated from, an existing definition under 626.5572. This one is sub 9. Financial exploitation is defined as a breach of a fiduciary obligation that's recognized elsewhere in the law. You've breached it, and then you've also engaged in an unauthorized expenditure of funds that were entrusted to you by the vulnerable adult that is likely to result in the detriment to that vulnerable adult, or you fail to use the financial resources of that vulnerable adult to provide necessities like food, clothing, shelter, things of that nature. In the absence of legal authority, so that first one is if you do have legal authority over that vulnerable adult. It's also financial exploitation if, when you don't have that legal authority, you still willfully use or withhold or dispose of funds or property of the vulnerable adult, or if you obtain services by a third person that will wrongfully profit or advantage myself or this other person to the detriment of the vulnerable adult. If you acquire or get control of an interest in funds or property of the vulnerable adult through any sort of undue influence, harassment, or duress, etc., that is considered financial exploitation. Also, if you force, compel, coerce, or entice a vulnerable adult against their will to perform services for the profit or advantage of the, in this example, it's myself or whomever, for the profit or advantage of another, that is also considered financial exploitation. So key elements here across the board, it includes, wrongful taking, wrongful use, or, withholding or retaining those funds or assets that belong to the vulnerable adult. Um, it would involve, undue influence to obtain these assets or undue influence in manipulating that vulnerable adult's decision making. So, putting that into a practical example, some examples of financial exploitation are the unauthorized use of a vulnerable adult's credit cards, failing to, let's say you're a rep payee, but you fail to use the financial resources of that vulnerable adult to provide health care and necessities. You're not giving them, that payout per month so that they can use it for groceries, etc. If you misuse your power of attorney, that's another one. If there are, if you obtain gifts or transfers through coercion, that is also considered financial exploitation, as an example. And then also romance and caregiver scams, those are really, really prevalent, and things like identity theft, that is also considered financial exploitation. And so you can get an order against a scammer or a fraudulent identity thief through this statute. So let's check out the elements that a court needs to make sure are met in order to find that financial exploitation happened. So, to issue temporary or final relief, the court must find that the vulnerable adult is a victim of financial exploitation or is in imminent danger of it. There is likely irreparable harm with no adequate remedy at the law available. There is, or the threatened injury to the vulnerable adult would outweigh any harm to the respondent. And this one's important because sometimes the finances are in joint accounts. And some might say, well, the respondent, has access to that. They should be able to access that too. Well, if they are acting in a way that is financially abusive, the court is going to weigh, well, is this threatened injury to the vulnerable adult, does that outweigh this respondent's access to that account? And if it does, then too bad. Uh, Issuing the order, the last element is that issuing the order would protect the vulnerable adult's financial security. Here's some other factors that a court may consider. It doesn't mean they have to. It doesn't mean they have to consider all of them. Just depending on the situation, some might apply and they can consider it. So they can evaluate all relevant factors, which would include current or previous orders for protection or harassment restraining orders, or any previous or current similar orders issued by another jurisdiction. If there has been a history of financial exploitation by the respondent upon this vulnerable adult or any other vulnerable adult. Likewise, if there's a history of this vulnerable adult's previous financial exploitation by this respondent or others. And the capacity of the vulnerable adult is something that they may consider as well. Are they able to make decisions related to their finances, related to their property? What is the vulnerable adult's susceptibility to undue influence? And then finally, they may consider the respondent's criminal history if they have any. So, who can file? Who can file for an order for protection to protect the vulnerable adult from financial exploitation? I do want to note originally in the domestic abuse order for protection, petitioners were very limited. It had to be the victim themselves, or you would have to be their conservator. This has expanded the ability for any trusted persons or advocates and other qualifying persons to be able to apply on behalf of the vulnerable adult victim, which is great. So eligible petitioners include the vulnerable adult themselves, their guardian or their conservator. That was in effect with under the DV OFP. But what's new is a person or an organization acting on the vulnerable adult's behalf with consent. They can um, be a petitioner on behalf of this vulnerable adult. An agent under a valid power of attorney can also be an eligible petitioner. That's new. Power of attorney was not enough prior to this to be able to be a petitioner. Also, any person who's simultaneously filing for emergency conservatorship, they can also petition on behalf of the vulnerable adult for this protection. So as I mentioned, the standing to file is now broader than under the original OFP. It's not limited just to the victim or a court-appointed guardian or conservator anymore. Let's take a look at the relief that is available from the court now. Looking at temporary and final injunctive relief, they're able to get more creative now that this statute has come out. Under the previous OFP, for the most part, the solution or relief was no contact. Right now, with this in effect, it's now uniquely tailored relief to fit and remedy that financial harm. There's also mechanisms of enforcement that involve financial institutions that were not available before, and mitigation of damage and prevention of further harm. So, what does that mean? That looks like examples such as prohibiting the abuser from having contact with the vulnerable adult. That's the classic. Restraining the abuser from committing acts of financial exploitation, freezing assets and lines of credit of the vulnerable adult, ordering payments of living expenses, even if the assets are frozen, and making the abuser move out of the residence that they share with the vulnerable adult. So, this order not only grants and protects the vulnerable adult and gives distance if needed, but it can also freeze accounts. It can also order somebody to do something for the vulnerable adult. It's quite powerful. I want to take a moment to note a new requirement that comes along with this statute. Under the previous order for protection that was involving just domestic violence, you didn't have to file any other reports, anything of that nature, along with your petition. For this, in order to get an order for protection and to file, you have to also make sure that you have filed a maltreatment report. I believe it's 24 hours beforehand. So petitioners will have to file a MARC report. MARC report is a maltreatment report. And the statute language says, unless a report was made before a petition was filed, the petitioner must then file a report within 24 hours of filing the petition. So, where can we file MARC reports? Complaints can be reported to the Minnesota Adult Abuse Reporting Center. That's MARC. You can call the phone number here on the screen, 844-880-1574. You can also find more information and submit a report online through the Minnesota Adult Abuse Reporting Center. It's a clickable link, so when Isaiah sends out the PowerPoint, you'll be able to click that and access it. Let's talk about emergency ex parte orders. So an ex parte order is a temporary court order issued by a judge immediately upon the request of one party, usually at that initial filing stage. The other party is not present when this is ordered, and they're not notified that a judge has decided to order that. It's used strictly in emergency situations, and they are of a temporary nature. So they only remain in effect until a formal full hearing can occur. For a court to be able to grant an ex parte order, the court has to find that certain elements exist. So the court, by looking at the petition that the petitioner has submitted or filed, they need to ask themselves, okay, does the contents of this petition meet the original elements that we just previously went over for a financial OFP? Does it meet those elements? If it does, great. On top of that, it has to also be able to show that there's an immediate and present danger of financial exploitation. And based on what we see in the petition, is there a substantial likelihood of success on the merits? If there is, then the court will grant an ex parte order. And that ex parte order will be in place until you get a chance to have the hearing. Looking at the evidentiary hearing process, a court has to hold a hearing within 14 days of receiving that petition. Of course, there's always some exceptions, right? If there's an ex parte order in effect, sometimes it might go beyond that 14 days, especially if, for scheduling reasons, if both parties agree to push it out. You know, sometimes it can go a little bit beyond the 14 days, but for the most part, a court tries to hold a hearing, and under the statute must hold a hearing within 14 days. But we know how scheduling can be sometimes. Final orders, when granted, can last up to 2 years, and they can be subject to renewals. And so if the abuser violates or is exhibiting behavior that would show that even after the 2 years have passed, this danger still exists, then these orders are subject to being renewed, and you would seek to extend them. At these hearings, both parties have a right to call witnesses and present evidence. It's like a mini trial. There are applicable witness and evidence deadlines you need to look out for. You would likely be notified of those deadlines in the notice of your hearing, and or you might hear the judge talk about it if you do have kind of like an initial introductory hearing before your big evidentiary hearing, you might hear them discuss that there. Just remember, witnesses that you want to call, you have to identify them in advance. You have to let the other side know that you're going to call them. And any evidence that you plan to show that day at your hearing, you want to make sure you've exchanged that with the opposing party and uploaded that to Mindy's. Mindy's is the court's, I would say, like evidence submission program. You absolutely have to make sure you upload your evidence there. And you can find Mindy's at the Minnesota Judicial Branch website. The burden of proof that you're going to have to meet at your hearing is called preponderance of the evidence. That's a common civil standard for many civil cases, Preponderance of the evidence essentially means it's more likely than not to be true. That's a lower standard than the criminal standard, which you may have heard that's beyond a reasonable doubt. This one is not that. This is preponderance of the evidence, or more likely than not. Um, as I mentioned, the court will apply to the legal standard, meaning the elements that we discussed in the previous slides. So, how do we file for this financial OFP? What documents do we need? Here are some key steps. One, file that MARC report. Because it's such a tight deadline of file the report within 24 hours, I recommend just make sure you get that MARC report filed beforehand. That way you don't have to worry about it. Then you want to make sure you complete the petition. You're going to have to allege actual financial exploitation or imminent danger of that exploitation. You want to make sure you include specific facts and talk about the relationship between the parties. The more detailed you can be in your, they're called affidavits, or the narrative section of the petition, the better. You want dates, you want, who was there, who was around, what happened, point by point. You also want to make sure you disclose prior protection orders. You also want to make sure, in addition to the petition, that you consider completing any other documents that might be relevant to you. So, for example, you're going to have to serve the other party, and so it's very likely you might have to complete an affidavit of service, whether that service be in person, or if you have to apply for service by alternative means. If that gets granted, then you can serve them in the mail, and you have to make sure you complete and file your affidavit of service by mail. If you're in a situation where you do not want the abuser to know your address, and you don't want your address to be visible during this court proceeding, you don't want it to be on the docket or on the record, you can complete and file something called a confidential address form. You also need to consider submitting a financial affidavit in support of your petition, because this is something of a financial nature, unlike that classic domestic abuse OFP. And if you are filing on behalf of the vulnerable adult, you will likely need to submit a consent to file the petition. After you have completed the petition plus any of those other documents I mentioned that might be relevant, you want to make sure you file that petition and you file those documents with the court. You would do that by going to the records or filing office in the county where either the petitioner, the respondent, or the vulnerable adult resides. Alternatively, you can use Tyler Host and file that online. But usually it's mostly attorneys that are registered for that, and the registration process is not always easy for all folks to get on there. And so if you want to keep it simple, you can go down in person to the courthouse and file it that way. You should know that unlike other civil cases where you might have to pay a filing fee, because of the nature of this action, filing fees are waived for both parties. After you file, you want to make sure you serve the respondent. Service rules are going to follow the same rules that the domestic abuse OFP follows. That's under Minnesota Statute 518B.01. The biggest rule being you have to try to serve them in person. That doesn't necessarily mean you yourself have to hand it to them, but you have to arrange for some sort of in-person service. If you can't do that because, let's say, the person you're trying to protect the vulnerable adult from is a scammer, some sort of AI scammer or identity theft person, you don't know their location or they're dodging, that's when you're in the territory of applying for service by alternative means, and you're trying to serve them in the mail or by publication. If assets are frozen or the petitioner is seeking to freeze assets, then you also have to serve the relevant financial institutions. that puts them on notice. You're then going to want to make sure that you're preparing for this hearing and attending that hearing when it happens. I can't emphasize enough, if you do not show to the hearing, it is an automatic loss and a win for the other side. No matter what, make sure you go. So, where can you find the court forms to do all this? Um, in looking through the Minnesota Judicial Branch website, I was able to find these two links where you can get an instruction packet for how to complete the financial OFP and then the financial OFP petition form itself. I did notice that the court has been, updating it, changing it. First it's available here, then it's available there. So um, just be aware that right now these links do lead you to those documents, but in the future, I'm not sure. But just know that the financial OFP petition form, the code for that, if you want to type it into the search in the Minnesota Judicial Branch website, that document is, the form is CIV 1102. You can also visit the administrative office at your local Minnesota District Courthouse if navigating that judicial branch website is difficult or you can't find it. The court is required by the statute to provide simplified forms and clerical assistance. So if nothing else works, go down in person to the courthouse and request those forms. And now let's look at the implementation. How is it going? What are the statistics so far that have come out? Well, as of March 2026, unfortunately, there's not yet data released on this. It's still so new. So there's no data available yet, really, at least not a significant amount on filings or grants or denials. You can always check with your local or state court admin, and they can kind of tell you what they have been observing and what the patterns are. Um, I can say that early practitioner observations have been that, the courts do appear to be taking um, docket priority requirements very seriously. The mark requirement that is now you're now obligated to submit that mark report. That's created some procedural complexity for petitioners because they might file the petition and then they realize, oh gosh, I didn't do that mark report within that amount of time. And then they have to start that process all over again. Financial institutions also right now are actively updating their compliance policies so that they can respond to these asset freeze orders that are coming out. Looking at some legal arguments that have been made thus far, arguments that are specifically pro petitioner, pro vulnerable adult. Those arguments are that the ex parte is helpful to prevent quick dissipation of financial assets. Dissipating the assets can happen super fast, especially if your abuser gets wind that you might be filing for something like this. So ex partes are extremely, extremely helpful to prevent the abuser from, draining what might remain of those accounts, or might prevent the abuser from doing some sort of act or not doing some sort of act that is harming the adult, the vulnerable adult. They've also made that argument that the broadened standing allows trusted advocates to act when that vulnerable adult lacks capacity. That's important because sometimes the vulnerable adult is not, um, is not aware of the situation fully or is not able to act and go through this process. And so to have others that are able to qualify to be able to do this for the vulnerable adult is fantastic. Relief is more accessible now under the preponderance of the evidence standard. So now looking at some legal arguments that are pro-respondent or against the vulnerable adult. They have been arguing that freezing the assets without prior notice or a hearing is raising 14th Amendment procedural due process questions where the respondent will have legitimate financial ties to the assets. So this is that joint account example I mentioned earlier. They're arguing that, freezing that without notice is harming the respondent. They're also arguing that there are standing challenges on whether, a power of attorneys, an agent or an attorney in fact, whether their authority is specifically granted when that POA language is ambiguous. They're also challenging whether the vulnerable adult, whether the victim meets that legal definition of a vulnerable adult. So those are different arguments you might see respondents raise in this court process. If you believe that you or somebody you know is experiencing financial exploitation, do not hesitate to contact SMERLS, especially if you're in that trusted position, as I mentioned, or if you are a power of attorney or anything like that. Please do contact SMERLS. I wanted to take a moment and let you know that you can submit an intake and leave our hotline number here. It's 1-877-696-6529. You can also submit an intake online on the website. I have the link there. Just note that our intake is available from 9 to 3 every weekday. We're not available on weekends or on holidays. If you are interested in just getting general legal information, you can also visit lawhelpmn.org. If you want to visit our office real quick, these are our different office locations, depending on where you're watching from. Just find the one closest to you if you want to pay us a visit. And if you like this webinar and are interested in attending or registering for future webinars, you can register in advance. These recordings are sent out to registrants after the presentation. I've left the link here. It's www.smrls.org/online learning. That's where you can sign up. If you want more information about these sessions, please contact us at laop@smrls.org.
That's awesome, Jen. Yeah, thank you so much for that. Yeah, a whole bunch of good stuff in there. As she mentioned, once the recording is uploaded to YouTube, I'll be sure to send out an email letting everyone know. And yeah, if anyone has any general questions in the chat, we can surely take a look at some of those. If you think that you may have specific questions that are specific to your situation that might need you to give personal details, it is best to contact us through our intake line to see how we can help. But yeah, I will give a minute and see if anyone types any questions, and if I don't see any in the next minute or so, I think it's good to call it a day. So if you do not have any questions, you can certainly head out now. So
And thanks, you guys. Thank you guys for listening. And a good afternoon, or good morning, or good evening, whenever you might be watching this video. If we do have any questions, Isaiah, would you mind reading them to me? I don't think I'm able to see them.
absolutely, yep,
Okay.
absolutely. I'll give it a little bit more time here to see. All right, and not seeing any questions, so yeah, I think I will go ahead and yeah, end the meeting for everyone. And yes, if anyone does have any questions later, again, yeah, do feel free to please look us up and contact our intake line and see if we're able to help with any questions you may have in the future. But yeah, that being said, thank you, Jen. Thank you everyone for coming, and yeah, maybe we will see you next time. Take care, everybody.
Thanks. Bye bye.